Jen and Matt. Jeremy, we all know as our AGIS research director. He has been a dedicated partner in the good work of this committee. So thank you, Jeremy. Jen, attorney advisor with a past life as an academic. She's got a great role to play here. And then rounding out the team is Matt Bluth, AGIS deputy research director, fellow UConn Husky. We can't go wrong here. We're in great hands. So we have a lot to cover. I want to turn things over to, I believe it's going to be Jeremy and Jen doing the kind of the brief presentation, and we want to hear about their report and the work that they've done. And then we will tackle our next steps. So Jeremy and Jen.
Great. Thanks, Nadine. Yeah, I'll take the lead here, but Jen, feel free to jump in and correct me whenever I get things wrong. But just to add to the thanks again, this was no one person's job, and really thank you to the entire team for pulling together to do this project. I know it was not an easy one, but it is a timely and important one. So I'm talking to a room full of experts here, so I'll try to keep the presentation short and maybe leave a few things for discussion. This project examines as a legal and practical matter whether, when, how, and how often agency heads and other Senate-confirmed officials, PAS officials, participate in the adjudication of cases across a range of federal administrative programs. It's intended to identify principles and practicalities that agencies should consider in structuring participation by PAS officials and recommend best practices for developing and communicating relevant policies regarding such participation. The project does not address whether agencies should, for constitutional or other reasons, provide for participation by Senate-confirmed officials in specific programs. You'll also note that the recommendation we've drafted makes no recommendations to Congress, in part given sensitivities around evolving separation of powers case law. So let's begin with the elephant in the room, Arthrex. There have always been questions about whether, when, how, and how often PAS officials should participate in adjudication. In 1790, Congress assigned patent adjudication to 3 cabinet secretaries. That quickly became unworkable. By 1802, Secretary of State Thomas Jefferson had established a dedicated patent office within the State Department to handle the growing workload. By 1836, we see a corps of professional patent examiners in place. After 185 years of regular and active executive and congressional modification to that system, we arrive at Arthrex. A growing line of cases stand for the proposition that at least those adjudications that involve a relatively formal trial-like process must be performed by constitutional officers, and that those officers must be appointed by the president and confirmed by the Senate, or alternatively, directed and supervised by one or more PAS official. The question is, what constitutes direction and supervision? Direction and supervision can take lots of forms, many of which AGIS has previously considered. It can be appellate review, it can be quality assurance, it can be personnel management, it can be substantive and procedural policymaking, etc. Edmund v. United States, argued by our very own Alan Morrison back in '97, found that the judges of the Coast Guard Court of Criminal Appeals were adequately directed and supervised because a separate executive branch tribunal, an Article I court made up of PAS officials, reviewed judges' decisions, because a PAS official, a JAG, could remove judges from their judicial assignments, and because a PAS official established procedural rules binding on judges. 2 of those 3 factors were missing in Arthrex. No PAS official had statutory authority to review the decisions of patent trial and appeal board panels, and administrative patent judges are subject to the standard Title V employee restriction on removal. The court concluded, quote, "Today we reaffirm and apply the rule from Edmund that the exercise of executive power by inferior officers must at some level be subject to the direction and supervision of an officer nominated by the president and confirmed by the Senate. Hence, today's project, the participation of Senate-confirmed officials in administrative adjudication." I expect that in the course of this committee process, we'll need to reckon with how best to interpret Arthrex. Several scholars in the few courts that have considered the issue since seem to have come to the conclusion that adjudicative functions remain broadly delegable to executive branch officials, absent a statutory directive to the contrary. Though, of course, interpretations may differ, and this recommendation as drafted would offer agencies a blueprint for involving PAS officials in the adjudication of cases, no matter the interpretation they choose. At the very least, Arthrex limits the options available to Congress in structuring administrative adjudication. And so we've omitted recommendations to Congress from our draft, though of course nothing in Arthrex suggests that Congress can't designate which PAS official should, say, review the decisions of non-PAS officials. So for this project, in addition to examining background legal principles, we undertook a broad exploration of federal programs, including a deep dive into a good number of programs, which you'll see in the appendices, to better understand policy and practical considerations, and to understand how agencies have navigated today, but also historically, legal, policy, and practical trade-offs to develop their own unique practices for participation by PAS officials. As a policy matter, we identified 8 typical, but not necessarily universal characteristics of PAS officials that may affect their performance as adjudicators. It's detailed in great length in our report, but briefly, first, it takes a pretty long time to appoint PAS officials. ACUS has looked at this in the past in terms of acting agency officials. PAS officials also serve relatively short tenures. Third, fourth, and fifth, PAS officials have unique relationships with the president, political appointees, the agencies, and the Senate. I blitzed through that, but there's a lot to unpack there, and I'm sure we'll continue to do that throughout this committee process. Sixth, PAS officials are assigned a range of duties. Sometimes there's a tension between those duties. And even as a practical level, capacity may simply be lacking given the breadth of duties. Seventh, PAS officials occupy unique high-level positions within bureaucratic hierarchies and at the end of decision-making processes. And eighth, maybe less important, PAS officials make for pretty expensive adjudicators. Lots of consultants for ACUS and ACUS members in their own independent writings have examined the potential advantages and disadvantages of agency heads, in particular as adjudicators. On the potential advantage side, we find centralized coordination of policymaking, political control of policymaking, greater access to expertise in policymaking, ability to gain and act on systemic awareness, ability to promote interdecisional consistency, and ability to make difficult decisions. On the disadvantage side, we see lack of adjudicative capacity, potential to increase the duration and cost of adjudication, limited opportunity for party participation in cases that affect them. You see this more at big executive departments than at independent agencies. Limited opportunity for public participation in policymaking that takes place through adjudication. Incentives to develop policy through adjudication rather than rulemaking. Frequent turnover. Perception of unfairness and impartiality when political appointees engage in adjudication. Lack of specialized expertise. And finally, the risk of political manipulation. But with some exceptions, participation by PAS officials is not a binary. It's not an either or. Either you have PAS officials or not. In many cases, in most cases, it's a question of how you structure PAS participation. There's lots of decision points that policymakers need to consider in actually facilitating effective participation by PAS officials. Even the APA, which grants agency heads on review all the powers which it would have in making the initial decision, permits agency heads to limit the issues it will consider on review by rule. We found, in fact, that participation of PAS officials looks very different across agencies and programs, particularly between independent agencies, where the agencies themselves often serve as an appellate body, and large cabinet level or executive departments where agency heads might serve as a second or even higher level of review and intervene infrequently, if in fact they ever have in their history. And that's really the bulk of this recommendation, recognizing that many agencies with many different programs and many different needs will need to consider how to structure review by a PAS official, often the agency head, not always the agency head. In this report, seeks to identify all decision points agencies will confront along the way, and the recommendation seeks to identify best practices to help agencies navigate those decision points. Finally, it emphasizes that the recommendation emphasizes that a complaint in many systems, again, typically in larger systems, but not always, has been one of seemingly random participation by Senate-confirmed officials and a lack of transparency regarding rules, policies, notice of participation in individual cases, and decisions by Senate-confirmed officials in individual cases. So it also encourages agencies to codify their policies and make materials publicly available. I am sure we will have lots of debate throughout this project. I'm excited to discuss it with all of you. And I think with that, Nadine, let me turn it back to you.
Thanks. So before we kind of dive in, we do have a lot to cover, and I hope to really cover some good ground today. I just thought it would be helpful if there's some general questions for Jeremy or Jen about the report itself, if there's any comments, questions before we dive in. Okay. Not that you can't ask questions later. But, okay, so Matt, do you want to put the document up? There we go. Can everybody see okay? Are we good on that? So I know Jack has comments here, but I don't believe he's joined us yet. So I think it would be helpful for us to start with the preamble, and maybe rather than do a line by line kind of editing process before we dive into the recommendations, if there are some broader thoughts or broader concerns, or I know Russell Wheeler had some comments as well. So this first paragraph looks like it's mostly Jack. I believe, I'm trying to see, there's two comment bubbles there, so maybe Russell is up there as well. Yeah, there's Russell. Russell, would you like to just talk a little bit about your concern there?
Yeah, well, yeah, I preface it by saying when was it Jeremy or Matt who said he's talking to a room full of experts? That doesn't include me, that's for sure. So this may be a naive question, but I was just not entirely sure to whom the recommendation was directed. Is it directed at agency officials other than the presidentially appointed, or are they included? Maybe I'm missing something, but on the other hand, would it be helpful to distinguish that? I had the sense sometimes I was reading that it was up to the non-presidential appointed people to set things up for the PASs, and they weren't to participate in setting it up, but obviously they have a role. So maybe I'm missing something, but that was my comment.
Thank you. Russell, Jeremy, or Jen.
No, you're not missing something. We actually struggled with this in drafting. So we're in different places talking about positions that are filled through presidential appointment and Senate confirmation, the officials who occupy those positions. And in some case, we're talking about agencies, which often are basically the positions that we're talking about, right? When we refer to an agency in the APA sense, we're talking about the position to which a function is delegated. So we struggled in making those distinctions because we also don't want to give the impression that every time an official moves into a PAS position, they should necessarily promulgate a set of regulations describing how they personally will exercise authority. Now, of course, they might have authority to go back and modify and revise as needed, but I think it probably behooves all of us to pay attention to those distinctions as we're reading through this and figure out what is the best way to talk about the position, the person who fills the position, and the sort of agency as a, I don't know, ongoing historical entity.
Would there be any benefit in a two sentences in the preamble repeating what you just said?
We could take a stab at that.
Well, don't do it just on my account, but if the other committee members think there's anything there, you might want to do it.
No, I think it from my perspective, it would be helpful. This is an area where I really struggled as we were discussing things and thinking them through. So if the fact that we as a team struggled a little bit to identify this, and you as a reader are struggling, then that suggests that we need to be more clear, I think. And by setting it up in the preamble, then that primes us to think a little bit more carefully about how we're phrasing these things when we get to the recommendations.
Okay. Thank you.
I agree. And if there's any other comment on that, I think if Russell's flagging it and you all, as Jen said, struggled with it as well, it's someone picking it up cold is going to feel the same way. So if we can do that. Roxanne, please.
Yeah, thanks, Russell, for identifying that. And it's interesting to hear what you went through trying to draft this. I would say, at least from our experience, that any procedural or rules that we have as to how the adjudication takes place with the PAS members making the decisions, it is definitely something that is a joint effort between the career employees and the PAS. So the career employees, we often are in the weeds and we know what works and what hasn't worked, and we can make recommendations, but we can't issue any rules without the PAS folks approving them. And so, we may bring to their attention, well, we're having this particular issue we need to deal with in our rules because it hasn't been addressed before, it really should be, or it is addressed and it's not quite working the way I think it's intended. Not we. But yeah, so in terms of who is this written for, I think it's got to be written for both the PAS and the career employees, because neither of them will act to make changes without the other.
I think that's a great point, Roxanne. I was actually thinking in this text that's spanning 6 to 9 that it would be nice to say it is PAS officials who, hand in hand with career government employees, do all these wonderful things in implementing the agency's mission and all of these great things. Anyway, thank you, Roxanne. Any other comments on this point? Okay. Matt, Jack is here. Should we go up to Jack's comment? Generally, Jack, are you here?
I am here. Sorry. I just got back from umpiring a high school baseball game, so
Wonderful.
went a little long. Yeah. I mean, I don't know where you are, and it's not,
So,
I don't want to.
Yeah, I can give you a little prelude to where we are. We just started with the preamble. We're not really doing line by line. We're just kind of thinking broader strokes. And
Okay.
one of your comments, I guess, is this first comment about PAS and whether it's a synonym for principal officer. I didn't know if you wanted to speak generally to that, and then we could think about if there's something that can be done later on to address that.
Yeah, I when I read this, so most PAS officials are inferior officers, right? Because they're subject to supervision by someone above them in the hierarchy. It depends on your, it may depend somewhat on your definition, but because it seems to me that almost anyone who presides over a hearing is likely under the law to be considered an inferior officer, right? So then the sort of the nagging question I have is, understanding the Arthrex remedy, if you have a PAS person who's still an inferior officer, does the fact that they were appointed by the president with the advice and consent of Senate cure the Arthrex problem? I guess maybe it does, but I'm having a little trouble wrapping my mind around it. I guess because again, PAS and principal officers are not synonyms. I mean, principal officers are a subset of PAS officials. I don't know
Jeremy?
if it matters at all. I'm not sure if it matters.
No, I agree. I mean, I think Arthrex does answer it, because when Congress could have said this has to go to the Secretary of Commerce, the Secretary of Commerce, as a principal officer, the head of a department, must have authority to review APJ decisions. It was actually given to the PTO director, which, as John Duffy has written, may not be a department head for other purposes, is certainly statutorily subject to the supervision of the Secretary of Commerce. And so it seemed okay there. And I think in Edmund too, where they talk about removal by sort of a JAG within a Coast Guard structure who happened to be Senate confirmed. In Arthrex, they basically just come to the conclusion, we reaffirm and apply the rule from Edmund that the exercise of executive power by inferior officers must at some level be subject to the direction and supervision of an officer nominated by the president and confirmed by the Senate.
Right.
My
So
sort
the-
of read is that there's sort of principal functions and inferior functions, and that a principal function performed by somebody who's not confirmed by the Senate is a problem. But ensuring that someone who is confirmed by the Senate is performing some sort of principal function seems to, at least in the court's reasoning, solve the constitutional defect.
Okay, but so then doesn't that mean that you have to have a PAS in every imaginable agency adjudication?
So there have been an interesting development since Arthrex. So, I mean, the issue that arose in Arthrex on remand was the fact that there actually was no Senate confirmed director in place. In fact, there wasn't even an acting director in place, given the operation of the Vacancies Act. And so the issue arose of, could a career appointee performing the duty of the director actually perform director review? And the Federal Circuit said, sure, because even this review authority is generally delegable. Other sorts of functions of the director have also been found to be delegable. So it seems to be what you're seeing in this sort of evolving case law, and it's very limited, I will say that, is that unless adjudicative authority is clearly non-delegable, it is presumptively subject to delegation. And that the delegation itself still retains the sort of chain of dependency, because if you make a bad delegation or you don't act on bad things that happen after a delegation, you might still be held accountable to the president, to Congress, et cetera.
And so they can delegate to a non-PAS official?
Yeah.
So then why couldn't they just delegate everything in Arthrex to the PTAB?
I mean,
that doesn't make sense to me.
Some agencies do it that way.
It sounds to me like either Arthrex is wrong or this is going to end up, if someone challenges it, it's going to end up getting thrown out. And so I'm sort of, I mean, maybe I'm just off base on this, but it just seems to me that there's that it really, at least it needs to be sort of understood in this, that you may need a PAS official with ultimate authority in every single adjudication that the federal government does. And, I can tell you, there are thousands of them every year where there's no one even close to a PAS person that does them.
Well, the question is whether someone has statutory authority, right? So in many cases, I mean, under the vast majority of statutes, Congress simply says the secretary of such and such shall do X. And in no case has the secretary of such and such ever done X. In fact, what we see more often is, Jen did a case study in the DEA. It's assigned to the attorney general. It's delegated to the DEA administrator. Now, the DEA administrator actually is a PAS official who gets involved.
Right.
But
right.
the attorney general actually has statutory authority. And you see lots of examples where the secretary of the Treasury, if you're talking about garnishment cases, might actually have authority under the statute.
The statute is clear that the garnishment decision is by the low-level official, and it goes directly to, the only appeal is to the courts.
Well,
so they would have to rewrite that statute.
That may raise an Arthrex, and you do see things like that. I mean, the big example I think of that is consular cases, visa processing, where consular officers issue decisions and there's no higher level review.
Yeah, and those people maybe, they're definitely at least 2 levels of for cause away from the president.
Yep.
So there's huge constitutional problems lurking in the background of this, and I'm just not sure whether maybe we should just ignore that. Maybe there's a footnote that says, there are all kinds of structural constitutional issues, but it just made me queasy when I was reading this that we seem to be sort of ignoring that. And I'm not criticizing anyone for that, but that it just seemed to me to raise all kinds of difficult and interesting questions. And I'll just leave it at that. I don't want to prolong I think this is an excellent, the parts of the report I got to read and the recommendation, they're all substantively, I agree with, I think they're really well done. I agree with almost all of it. So I'm not sure what we do with this, but it just struck me as that we're talking about lots of stuff that's unconstitutional under the way the Supreme Court decided Arthrex. And maybe they're just going to be more flexible in applying Arthrex than they were in deciding it. Because if you're allowed to delegate to a non-PAS official, then Arthrex makes no sense.
Matt?
I just want to concur with Jeremy. I read Arthrex and certainly others do. This is not this is not original with me. I read it as dealing with um, Congress's allocation of decision-making authority within agencies, not agencies' internal decisions in that respect. And I just sort of would add, echoing Jeremy, that the chain of accountability, if you will, if that's the phrase, he used that concern the court in Arthrex is not a concern when agencies internally choose to delegate. And I guess relatedly, I would say, there actually may be language in Arthrex that suggests the interpretation that Jeremy's advancing here. But regardless, I don't think it's something that ACUS should or needs to address in this recommendation. Whether there should be a footnote identifying the issue is another matter. At the end of the day, it's going to be up to agencies to, until the courts speak directly on the issue, to interpret their constitutional obligations. And if an agencies decide that for constitutional reasons, a PSS official has to be involved in the decision making, this recommendation, as Jeremy points out, offers them a blueprint for doing precisely that. So that's all I have.
Thank you, Matt. Any other comments on this? Any thoughts about whether a footnote should be added? It sounded to me like Matt was thinking one would be okay, Jack as well. I guess the idea is just to, I think, Jeremy, you said at the outset, the elephant in the room, just to acknowledge that it's there and we saw it and we know that, I like how Matt put it, we have faith in agencies to figure out how to navigate these issues. Any thoughts on that? Comments before we move on? Okay, great. Thank you. So let me see where we are next. I'll let Matt finish typing. Okay. I think we had a line, a little wordsmithing there. Yeah, from Russell. There's no comments on that. Well, I see Russell's point. Let's move on to the next. Russell, do you want to speak to this? I actually had a thought on it as well.
It was just a small point that it seemed to me it was not that the text perhaps underestimated the difference between the length of service of most political appointees and most career civil servants. It wasn't anything more than that, Nadine.
Yeah, no, I thought the same. Jeremy, did you guys have any reaction, Jeremy or Jen, to this change? Did it strike you as inaccurate?
The one thing that I would say is when we there empirically there is a difference here between the independent agencies and the executive departments when it comes to thinking through the tenure. While I think it's still right, the difference is much less stark between careerists and PAS officials. So just something to, I mean, I'm fine with almost always, but I just thought might be worth just noting that there is that difference.
Well, my only point was that often perhaps understated. That's all.
Mm-hmm.
Often sounds like, one more than the other.
Okay. Any other comment on that? We'll move on. Jack, you had the next comment about under what what support do we have for the idea that PAS officials would be more responsive to Congress because they're confirmed by the Senate? Jeremy or Jen, any comment on that?
Jen, I'll turn to you actually on this one.
Yeah, so in the report, we talk a little bit about this. There tends to be a consensus that a couple of things. It may be there's some empirical evidence that that agencies that are led by PAS officials or decisions that involve PAS officials tend to be more responsive to political concerns and congressional concerns and inquiries as well, which honestly is the whole purpose of them, right? We would hope that one of the reasons that we have PAS officials is to hold the executive branch a little bit more democratically accountable. So there is some evidence to that, and we do cite that in the report. In addition, there is a different relationship with these officials and Congress due to the nature of potentially the confirmation and nomination process, in that the amount of evidence, investigation, et cetera, of the agency that is done when someone is nominated to the Senate. Often Senate hearings can be used as a sort of benchmark for how the agency is doing and where the agency is going to go. And in that sense, too, we do see around these discussions and the confirmation process itself that the agency tends to be a little bit more sensitive to the Senate at this particular moment in time. So those are just two empirically demonstrated reasons that we talk about in the report.
Yeah.
Yeah, so I haven't seen the empirical evidence, and it may be right. What makes me queasy about this is more responsive to Congress, because I mean, that in my mind, if you say more responsive to Congress, it would mean they'd be more attentive to their statutory obligations. When you're talking about individual members of Congress who make queries or put pressure on, or even in some independent agencies, I've heard of commissioners basically taking instructions from members of Congress on how to vote on particular matters. That is not democratic accountability. That's under the table perversion of democracy. So if there's evidence that they're listening to members of Congress, that would be anti-democratic, in my opinion, and it would undercut the accountability that they have through the president. And I have a paper on this called Congressional Administration, where I talk about this, and it would seem to me that it's the person who can remove you that you're likely to be the most responsive to. Now, and that's why in independent agencies, my understanding is members of Congress have a real strong amount of influence because the president is relatively disabled from removing them. And the pipeline to an independent agency is often runs through a member of Congress's or a committee staff's office to become a commissioner or a board member or something like that. So I'm just, I just don't buy the idea that being presidentially appointed and Senate confirmed makes them more democratically accountable. I think maybe it makes them more accountable through the president. But and again, if the evidence shows that they listen to individual members of Congress, to me that's a bad, not a good. But maybe I'm misunderstanding.
No, we cite that particular article that you mentioned several times in our report. I will say that I think you're absolutely right that the term Congress here, and I will take accountability for this because of my political science background, right? And this is a big problem that we have when we say Congress. Do we mean committees? Do we mean members? Or do we mean Congress as the institution? Because those are three very different things. I will say one thing that we have to think about here too with respect to this is it that PAS officials are more responsive to Congress relative to the president, or are they more responsive to Congress, period? And I think that the latter part of what you were discussing kind of gets at that. We do find that when you're subject to removal, you tend to be more responsive to the president. So the perception would be that Congress is less, but that's a relative perception as opposed to an absolute.
Roxanne. We lose her?
All right. Sorry, I thought I didn't click the mute.
No,
Mhm.
totally
Okay.
fine.
I don't know if this solves the issue, Jack, but what if it was phrased slightly different where it said PAS officials are also confirmed by the Senate, which may make them more attentive instead of responsive, attentive to Congress than career agency officials. I throw that out there because, I mean, I don't know even how you would come up with statistics on this matter. I think this would be a tough thing to study. But certainly to the extent that PAS officials have limited terms and they potentially want to be re-upped, they're going to be paying attention to what the Senate or Congress is saying to them. And it could be that they get letters from Congress people that they respond to, but they don't exactly do what the congressperson is telling them they need to do, but they are definitely going to be attentive to the communications that they get.
Can I
Go ahead,
respond?
John. Yes,
So,
yes.
yeah, I guess, and I'm only one person, so, I mean, I don't even vote anymore, so I don't think, but anyway, I just don't think that it's proper to use the word Congress here. And I think, they may be more responsive to individual members of Congress who, illegitimately put pressure on them or, have legitimate constituent interests, whatever. But and I don't see why that has to do with whether they're confirmed by the Senate or not, because they have to be nominated by the president. So I mean, I suppose they're going to be more attentive to members of Congress input than if they're a career civil servant, but the career civil servants are not going to be attentive to the president either. They're just not going to care unless the president has removal authority to them. Then they're going to care. I just disagree with this use of the word Congress, and with I'm not clear on any sort of causal link between Senate confirmation and responsiveness to even the sort of what I consider, illegitimate input by members of Congress. I mean, maybe that's true because they do make promises sometimes during the confirmation process. That they can get called out on, but I'm queasy about this whole thought, and I don't think it's a good idea to legitimate the notion that people on federal agencies ought to be listening to input from individual members of Congress who may get excited about it. I think you don't have to look past the Keating 5 scandal to figure out what's wrong with that.
Russell.
I didn't read the statement as a prescriptive statement, but rather, in a sense, as Jack said, all I thought that referred to was things like during the hearings, the member, Senator Snort says, "Do you promise that you'll give more emphasis to X program?" And the nominee says yes, and that creates a certain degree of responsiveness. I didn't think it was much more than that. Maybe I'm wrong, but perhaps if you tied it more into the exchanges that occurred during the hearings, that would begin to narrow it down.
I also wondered if it might be helpful to drop I know we have several footnotes where we're citing to the report. If there's a cite to the report we could add there that might help clarify where we're getting this statement. Any other comments on this point? Peter?
Yeah, hey, good afternoon. Sorry I'm a little late to the show. Coming from DOL as a career official, this reads just a little editorializing. It leads to me less of a factual statement and more of an implicit bias that, career staff may not be responsive. They still respond to oversight requests, congressional inquiries. So again, I'll say as a lay reader, it felt a little, maybe some implicit bias here towards career staff. And I didn't feel that it really added that much when I read the whole document. I'm not sure how much this one line sways me. So just food for thought. Thanks.
Okay, thank you, Adam.
Hi, my comment isn't exactly on the precise point we've been talking about, but rather kind of a couple sentences up, with the sentence that begins third, unlike career civil servants who are hired on the basis of relative ability, knowledge, and skills. It just seemed like that sentence was a bit more suggestive than it needed to be. In that, at least when I read it, it seemed to suggest that PAS officials are not nominated and appointed based on their ability, knowledge, and skills, and they're not retained on the basis of the accuracy of their performance. Whereas, I mean, I think just the point that was trying to be made was that the civil servants aren't hired based on their political beliefs, whereas that's total fair game. And obviously it's probably the driver as to why PAS officials put in place. But I think in some cases, many cases, the PAS official can have a tremendous amount of knowledge of the industry that they're regulating, or you know, can be have quite a good number of skills, and that's important to their to the job that they're doing. But
Adam, would you then maybe just, I think I heard you say this, unlike career civil servants who are hired without regard to political affiliation, activity, or beliefs? And take
yeah, I think
out-
it's just that would get the job done. But
Yeah.
but again, I mean, maybe there was a reason why it was
Yeah.
that.
No,
that-
I hear what you're saying. I didn't read it that way, but I could see it being read that way. Any comments on Adam's comment? And then we can just return to the Congress point. I think you raised a good point, Adam. Thank you.
Sure, thank you.
Anybody else on that? We can give more thought. I mean, I suggested a footnote, but I don't know if, perhaps there's another solution there to think about. If it makes people uncomfortable in the same way that Jack is concerned. And I'll open the floor to that. If there's any further comment. I mean, I do see it as there's 3 lines here under this third point, and it's the third line of the third point. So maybe it's a question of whether we need to make the point, and if we do, if we can put support with it, I think maybe that helps. Okay, let's move on to, let's see. Jack, you had a comment here about Lucia.
Yeah, I mean, my thought was, don't you have to have a department head appoint any of these people? I mean, it has to be the department head, right? Not even just PAS, who appoints anyone that adjudicators. PAS officials. It has to be a department head, right? Not just a PAS official.
Jeremy, Jen,
We had put in adjudicative personnel to be broader than adjudicators, to include
Okay.
things like staff support, the whole infrastructure around adjudication.
Okay, but it says positions responsible for adjudicating. I mean, they establish positions. I mean, can an individual PAS official establish a position and then also appoint the adjudicators? I mean, I think at least there has to be a clarification that we don't think that they can appoint the adjudicators. I mean, anyone who's an inferior officer has to be appointed either PAS or by the department head, right?
Right.
Yeah.
Of course, then you have even lower level decision makers who are routinely appointed just through traditional competitive service processes. So that you get into sort of maybe your tax garnishment folks probably fall into that bucket. But I mean, it's weird.
Well, I think under Lucia, they're inferior officers.
Could be.
And the Supreme Court has rendered thousands of administrative adjudications unconstitutional.
I mean, I guess the issue would come down to, does your frontline benefits determination, the person who does that, is that now an inferior officer? Is it only an ALJ who presides over a sort of formal hearing once a dispute is established? That's why we try to just leave it vague and say appoint and supervise or oversee the appointment and supervision. But I think we could certainly drop at least a footnote and say under Lucia, blah, blah, blah is the rule.
there's
Yeah,
a
I mean,
footnote
can
already
any
there.
can any agency official establish positions?
Some statutes authorize agency official. So, yeah, I mean, yes, kind of. I mean, the Board of Immigration Appeals is a creature of regulation established by the Attorney General in 1940. The Administrative Review Board of the Labor Department was created by the Secretary. So there are lots of examples where agency heads have created even like high-level intermediate appellate boards. Those are not provided by statute.
Okay. Anything else on this point? Can move on. We had a suggested edit in the next line, which I think is minor and doesn't need explanation. Move on to the next. Let's see. This kind of ties to our references above about the responsive. I think that's. You could scroll up a little bit, Matt, where it says may coordinate with the president and Congress. And then I think the addition is politically responsive. Any concerns about any of that language? Mhm. Okay. Okay, let's move on. All right, this is a broader concept. Russell, do you want to speak to this comment?
It's not a substantive comment, it's just a style. When I read the paragraph that we're looking at now that begins at line 39, it made sense. And then I read the next paragraph and I kept on saying, well, wait a second, we just said in the other paragraph, such and such. So I wondered if you might, I mean, it wasn't for me to do the drafting, that'd be presumptuous, but I just gave an example of how you might put the
Together.
the points in paragraph that starts in 39 and those that start at 53 and put them together. And I gave one example in the you know, in my comments and some other places where it might go. I don't know. It's just it's just whether it might meld those things together a little easier rather than reading a whole bunch of pluses and then a whole bunch of minuses. What we're really
Right.
talking about
You
is
pair them.
tensions.
You
Is
can pair
tensions
them.
here between
Yeah.
two characteristics.
Mhm. Actually, see your point about you're basically just combining the pro and the con in the same line, so you don't have to remember all the
Right.
pros and then look at all the
Yeah,
cons.
yeah, a lot of, yeah, on the other hand kind of thing.
Mm-hmm. Any comments on that? Committee on Style can handle that. Okay, great. All right. Do it, Committee on Style, I like that, Matt. All right, this was the Arthrex question that Jack has raised. You know, I think Jack, you missed Jeremy's intro when we were kind of recapping the report. I think we covered some of this when you joined the call. Was there? I think we're good on this point for now. We're thinking about recognizing the elephant in the room. Any other comments to add here? I mean, Arthrex is there, so we're recognizing it here. Maybe we just need to be a little more pointed about that. Okay, great. We're gonna move on. Jeremy had a question for the committee. I forgot about this one. Great. Okay. Jeremy, do you want to just speak a little bit about your question? I know
Yeah,
it's
it's a
there.
basic one. We talk about adjudication. Should we actually define adjudication? Some recommendations that ACUS has issued actually specifically define it, usually to limit it to what we're calling type A and type B, or maybe what we're not calling type A and type B adjudication now. Others define adjudication more broadly, just to sort of be any administrative proceeding involving a claim or decision against the government, by the government against a private individual, or involving two private individuals. And then there's some recommendations that sort of leave adjudication undefined. I'm agnostic here, but I want to raise it for the committee.
And if I could just second, I was thinking about this particular question during the discussion with Jack about what adjudicators are, and are we thinking about adjudicators in a more narrow sense in terms of ALJs, or are we thinking of all of those who are part of the adjudicate process more broadly? So that's an illustration of whether it would be beneficial or not to define our terms here.
Any discussion on that from the committee? Adam?
I would probably prefer to keep it broad and undefined. Just because I don't know the answer to this question about how many, the percentage of adjudications that are formal adjudications or with hearings on the record as defined by the APA. I know in the case of my agency, it's a relatively small number of adjudications my agency handles, which is we're principally an adjudicatory agency. So it seems like that could really having a narrow definition here could may really limit the impact or helpfulness of this of the recommendations.
Thank you. Jack?
Yeah, I guess is the committee's intent to limit this to adjudications that are governed by the APA, or is it supposed to be all adjudications? I mean, I would I mean, when I say governed by the APA, I mean governed by the formal adjudicatory procedures, and because to me it's the choice between that and the APA definition of adjudication, which is the procedure for formulating an order. Basically, that's it. And that's what I would, but I do think it's probably important to note if some definition and whether it's meant to be limited to a certain subset of the broad APA, definition of, any procedure for formulating an order. So I think there ought to be some definition listed.
Jeremy, I was gonna say Jeremy or Jen. Yeah.
Yeah. I mean, one concern is that, I mean, Arthrex is interpreted to define a certain role for principal officers in administrative adjudication, but I don't know how broadly Arthrex extends. Certainly, I think obviously it extends beyond pure APA adjudication because it includes the patent system, but how far afield does it go? Does it go to our favorite example of a camping permit at a national park? I sure hope not, I guess, but who knows? So part of it is I don't actually know what the breadth of Arthrex is or what might count as adjudication for sort of constitutional purposes, which may be one reason to leave it vague. In our report, we leaned on a definition that Michael Asimov gave in his source book a few years ago, which is this idea of administrative processes for basically adjudications involving members of the public in some way. We're not talking about policy implementation type decisions like locating a highway or naming or citing a post office, those sorts of things. So you could limit it in that way, but I don't know what the scope of Arthrex is, which is a challenge.
Any further thoughts there? I mean, we could cite to the report here and lean on the report. We need to. And I guess this question is whether we leave it vague. Any other thoughts, comments? Well, it's not in now, so we'll leave it as is. And we can always revisit if we need to. I would say resolve. Okay. All right, let's jump into the recommendation. I'm not eliminating the idea of line by line editing on the preamble at some future point, but I think it would be helpful for our first meeting to just plow forward and get into the recommendation. We do have a lot to cover. And I think we'll have an opportunity to revisit preamble line by line later. And some of what we do in these recommendations will impact what we do in the preamble. So I feel like we've made some progress there. We'll make more. Recommendation, let's start with, we can start with Russell's comment. Awkward sentences we do want to avoid. So to the extent we can avoid it here, I think that would be helpful.
Well,
but
the change I suggested is reflected on the screen.
on the screen.
Just getting that definition out of the first sentence and just stick it in the boldface. That looks fine to me, but
yeah.
What am I to say?
Any thoughts from others on this? Okay, and then anything on the first recommendation in that paragraph, aside from Russell's point? Okay, let's move to the second recommendation. Russell has a comment here as well.
Yeah, no, I just asking whether this was case by case or categories of cases.
So I think the change there is
Yeah,
reflected.
yeah, that answers my question.
Mhm.
If that's really what the authors meant, yeah.
Yep. Anything on that? And then we move to the list of, oh, sorry, Jack. Go ahead.
I
But
was
yeah,
late there. So are we, so we're assuming that constitutionally speaking, that that's okay to delegate review authority to a non-PAS official. So that no PAS official, once they delegate it, it's there doesn't have to be
oh, sorry.
an ability for the party to request review by a PAS official.
Feel like we covered this earlier, but I'm gonna put Jeremy on the spot to answer again.
So lower courts, and again, there's only a few examples since Arthrex seem to permit this at least for certain types of cases. So one that has come up is, so the director, USPTO director has fully delegated final decisional authority in institution decisions, or at least previously had. The Federal Circuit said that's okay because Arthrex says nothing about wholesale delegation of adjudicative authority by the director. Again, that's one Federal Circuit decision. It's by Judge Dyke, so it's I think a pretty prominent decision. You haven't seen too much other case law, but in the few cases that you do see, it seems to be pretty permissive of this kind of thing, so long as control is adequately maintained, however that ends up being defined.
The case you just mentioned, Jeremy, is post Arthrex.
It is, I can drop
Yeah.
a link into the chat. It's
Just making
called-
sure. I assumed it was. I just wanted.
Yep.
And if I could just follow up, this is an area that we did talk about, and one of the thoughts was that by having on line 112 and such authority is delegable as a constitutional and statutory matter, we gave us some wiggle room in case law changes over, which inevitably, as this gets hammered out, is likely to do.
Thanks, Jeremy. And Jen, but thanks for the case. Any other thoughts on this? I think we're okay. All right, let's move to the list. So these are the situations in which it might be beneficial to provide for review, and I think Russell, oh, sorry, I missed, sorry. Judicial officer, okay, Russell, do you want to speak to that comment?
What is it? I've never seen that term in an ACAS paper before. Maybe I missed something. It's all over the judicial branch, why use one syllable when you can use six? But does that refer to an ALJ, or is it any adjudicator, or what?
Jeremy?
So you see basically two different models of appellate review by non-PAS officials. One is you set up a sort of appellate board, and they hear, say, appeals from ALJs. The
Yeah,
other
you're
is you
right.
have a single judicial officer who hears appeals from ALJs or similar adjudicators. So I think the only two agencies I'm aware of right now that have judicial officers are the Agriculture Department and the Postal Service. Historically, EPA had one as well. There might be other examples out there, but it's the idea that instead of having an appellate board or an appellate body, you just have
No, I understand that, but I mean, I understand that. Couldn't you say you couldn't? I just never seen the term in ACAS papers before, and so it just surprised me. Couldn't you say administrative judge, or I mean, is that will people know what that means?
Is that the title they give them, Jeremy?
Yes.
Judicial officer?
Yeah, it's a judicial officer is like the final, basically it's the idea is that it's a stand-in for the agency head.
Oh, and that's the term. I mean,
That's
what
the title of the position at multiple agencies.
Oh,
I
Oh,
think
I
you
see.
you see it fewer, you see probably fewer examples of these over the years, but historically it's if you're setting up if you're delegating appellate authority, intermediate or final, do you set up a board to hear appeals, or do you just
No, I
have one
understand.
person who
No,
hears appeals?
well, that's interesting because, judicial officer, as I say, in the world I live in, that term's bandied around an awful lot.
Yep.
And it's just by people who want to, be heard, hear themselves talking a little longer. They don't say judge. Is there any way to indicate that that actually is an official term, not just a substitute for, substitute phrase for something else?
Jack, do you have a thought on this language we can use?
Yeah, maybe capitalize it. Because Jeremy's correct. I mean, when I was clerking in 1983, 84, the first two cases that I worked on were appeals from the Department of Agriculture, and the Secretary of Agriculture had designated a person as the judicial officer, capital J, capital O.
Uh-huh.
And that was the name of the person that the appeal came from. And then it turned out there was a little bit of writing I found out later about the unfairness or fairness of this particular judicial officer to the litigants. But anyway, that is a term of art. It's the title they're given in at least that department, and Jeremy's saying it may be in one other department. So capitalize it.
Yeah, that makes a lot of sense to me.
Great. Oh, I love solutions like that. Fantastic. Okay. I'm gonna try not to miss another. I think we can resolve that one. Okay, so now we're at our list. And I think, Russell, you're looking more stylistically here as to how we're
Yes,
defining,
yeah.
how we're, yeah.
Exactly. It's the
Yeah.
same point as above.
Mhm,
Individual cases or types of cases, and
right.
the correction answers the question.
So I think we're consistent throughout now, A through D, is it? Yeah. Any other concerns on the list from anybody? Jeff, welcome.
Hello, I'm sorry I'm late. I just got out of class. So I'm sure you probably just spent the last 40 minutes talking about definitions of PAS and things like that. But the only thing I had on this list was, shouldn't it be or rather than and?
Ah. Can we go scroll back up and we can read the preamble language to the list? Circumstances which may be beneficial to provide include. Huh. Any reaction to and versus or? I could see it both ways. Jack?
It has to be and.
Why?
Because it's not a
Because
checklist.
it's a list of the appropriate circumstances. It's not a choice. We're not going to decide whether one of these 5 circumstances merits it. We're going to say in all of these circumstances it merits it. It's not a choice. It's a cumulative list. Or it means you have to choose. It's like when there was an insurance company that did advertising that said we insure trucks or SUVs, and I always want to say which one. It's an and. Trucks, they insure trucks and SUVs. Your choice.
Okay. I'll take it back.
Anything further on the list? Russell had a change in C, which I think brings. Yeah. Adam.
Yeah, it just seems like maybe it's more of a question than comment, but it
Mhm.
seems like C in particular stands out as potentially much more broadly applicable than A and B and even D, because I think with D, I can imagine you could have a case that might be might fall within A or B, present some kind of novel issue, and then you would want a PAS official to decide that to promote consistent decision making should that issue arise. Again, in the future, almost like avoid something of like a circuit split among those who are delegated that authority. But C, I guess I have trouble imagining how that, like, what type of case is C trying to get at? That couldn't just be covered by some kind of report that's being made to the PAS, or them simply just reviewing the decisions of those to whom they've delegated authority. It seems like it just could be any case. It could be beneficial for PS to decide if it gives them some type of visibility in how the agency's system is functioning.
It's not necessarily a unique circumstance.
It doesn't. No, it didn't seem that way.
Okay, let's go to Jeremy and or Jen if they have,
I think you raise a really good point. I mean, this project is focused because Arthrex focused on it, on the role of what we call direct participation in the adjudication of cases. But there's obviously lots of ways that PAS officials indirectly direct and supervise adjudication, and one of which is to have, say, advisors who read lots of decisions and write reports on how a system is functioning. And one thing any PAS official has to do, especially one with lots of other functions and lots of other responsibilities that take away from adjudicative capacity, is decide, is it worth my time to participate directly in cases to gain systemic awareness, or is it a better use of my time and energy, and maybe even more accurate, to ask an advisor to prepare a report doing the same thing? We included C and D here. Yeah, these would not be limited to specific cases. The idea here is that you would need to like review a certain percentage of cases, or a certain number of cases, or cases with enough frequency that you're getting a sense of how things are going at lower levels of adjudication. Some scholars have pointed to a possible advantage of PAS adjudication as giving the PAS official better insight into how the system is working, because they actually have to work through cases themselves. The PAS official, given their role, actually might be the best person to act on that systemic awareness. There's also a sense that as the final decision maker, they can sort of ensure consistency. But I think those are normative assumptions, and the committee should decide whether those should be included on a list like this. I think we included them because they've certainly been proposed a lot in the past as possible advantages of PAS participation. But I think, Adam, the point you raised, how do you consider direct participation versus indirect participation, crucially important for this project?
Thanks, Jeremy. I will say again, like I like D like that, and I used the example of like a novel case, but it doesn't even need to be that. There could just be, it could become apparent that there's some issue that's being resolved differently depending on the decision maker to whom the authority has been delegated, and it just makes sense for the PAS to then weigh in to resolve that inconsistency. But yeah, see, just it seems yeah, harder to reach that example. But thanks, that was helpful.
Adam, would you consider striking C from the list? Do you think it's kind of mismatched with the others?
Yeah.
Okay. Peter.
Yeah, I agree with the points Adam was raising on C and D. And again, I think C just, we would find out at an agency in different ways. I'm not sure I'd get rid of it if that's been recommended elsewhere by ACUS. I don't have strong views. Again, I agree with Adam, it could come out. But Jeremy, if you're saying this is a recommendation that ACUS has made before, I mean, we don't lose anything by including it. I just don't think people will do it that often.
Not by ACUS necessarily.
Okay, all right.
By scholars who have, and I think scholars have differing views on the value of this. So it's one thing that has been cited, certainly in reports to ACUS over the years, as a possible advantage of PAS involvement. But ACUS, as far as I'm aware, has not specifically recommended it.
Well, we don't add any value statements or like, here are the most important ones. So you could include it and agencies could decide whether to, use C. I don't know that it's necessary, but again, if folks feel differently, could keep it in there.
Roxanne?
I agree with the idea of taking out C, because the way it's written, it makes it sound like it's how the system is functioning, and they're going to check it out every now and again. It also almost makes it sound like they'd be popping in and out periodically just to check on things. And that doesn't make a lot of sense for structuring how your system is going to work. I don't have any problem with D. I don't see a reason to take that out, but I agree with the idea of striking C.
Any other comments on that? Okay, we will move on. Let's go to 3. And this is kind of the different structural scenarios that could be used. I guess it speaks for itself. I was going to ask Jeremy if there's anything they wanted to add here.
For 3, all we tried to do was identify different different
Yeah.
structural options
Structural,
and then
yeah,
sort of explain when they might be useful. But I think it's difficult to capture every possible set of circumstances. So it's purposefully left sort of open.
Any comments on this?
Actually, if I could, one thing I didn't mention in my
Yes.
intro, we do see a really clear distinction between sort of first level review and second level review. We try to introduce those terms here. Maybe there are better terms. The idea is that at some agencies, especially at the independent agencies, you see basically ALJs or similar officers issue initial decisions subject to first level appellate review and final appellate review by the agency head. In other systems, you see essentially intermediate appellate boards, where a group of career adjudicators frequently will provide appellate review in most or even practically all cases, but there is some way in which an agency head sitting above the appellate board can serve as a sort of second level reviewer.
That's helpful. Thank you. Any comments on 3A, B, C? Okay, then I think we're up to the next section on initiating review. Oh, D, sorry, I forgot D. A, B, C, or D. Okay, let's move to 4. See, we have a comment from Jack on the last event.
Yeah, if I can speak to it really briefly, I just think his or her own motion is, I mean, that's a technical phrase. I'm wondering if his or her own initiative, so that some agencies may call it a motion, some may just say, do something else. Is that, I mean, if people think motion is really a term of art that ought to be used, that's fine, but to me, it read better to say initiative.
No reaction. I'll take that as agreement. Okay. Anything else on 4? All right, let's go to 5. And there's some edits here from Jack. Oh, no, these aren't your edits. I don't think. I think you just had a question. Jack, do you want to speak to this?
Yeah, I don't understand why the summary affirmance is not an option, even if you have an appealist right. You file your paper and then I mean, isn't that what happens in most NLRB cases? That the decisions of the ALJ or many at least are summarily affirmed. They just adopt the decision of the ALJ. I'm not sure. Is there a reason that I'm not aware of why there can't be summary affirmance in an appeal of right? I mean, the Supreme Court there was an appeal of right on all denials of federal rights, and 95% of them were just summarily affirmed at the US Supreme Court level.
Roxana, do you have any reaction to that since he invoked the NLRB?
I'm sorry, what was it again?
So, I mean, Roxanne, if the ALJ makes a decision and someone appeals to the board, can't the board just summarily affirm?
Well, the
Just adopt the
board,
decision of the ALJ?
yeah, the board will sometimes issue what we call a short form adopt, which is sort of basically what you're saying, which is they don't have much to say. They just say the ALJ was right. So we don't call it summarily, adopting it, but that's the effect. Yeah.
So I mean, it seems to me that everything before an agency should come out of number 5. But that's not accurate. I mean, unless we think that's wrong, that, the NLRB is doing something terribly wrong when it does that, which I don't think. I mean, it's what the
Jeremy?
Supreme Court did for 200 years.
The
Jeremy,
NLRB can't decline to review a case or take no action with regard to a decision that's. I mean, that I think would be the issue. I mean, would it make sense just to take out affirm summarily in that list? Jack?
Yeah, I guess that's the problem. Summary affirmance is not inconsistent with
Right.
with what practice, but maybe they can't, obviously, if they have the if someone has an appeal of right, they can't decline to review. They just have to, yeah.
Right.
Maybe that's right. I had it the opposite. You're right, 100%. Thank you.
Thank you,
At least I
Jeremy.
wasn't totally off base.
Not at all. Thanks, Jack.
Didn't mean to put you on the spot, Roxanne. Just
Oh, no problem. Sorry.
thanks. Jeff?
This is kind of stylistic, I guess, but circumstances in which a first level review may be appropriate include, and then all these things that are listed are sort of conclusory. I mean, there was committed, and so forth. So aren't we, I don't know how to draft this, but aren't we talking about sort of colorable assertions by the losing party that all these things happen? I mean, of course, if there was a procedural error, there should be review, but I mean, when the decision has to be made, they don't know what the answer is. So it's really what kind of challenges are being made at this point. So maybe it's clear the way it's written, but it just sounds too the circumstances have already been established by the time the decision is being made, if you get what I'm saying. So that's one comment. And then, you want to take that one up first, I guess?
What if it was first level review by a PAS official may be appropriate when?
When there's an allegation of, or when there's, when
Jeremy?
So we do get at that point of a sort of clear showing in recommendation 6. The reason we didn't put it here is presumably the same grounds might also apply in cases when an agency might decide on its own initiative to review a case. So there might be some indication that some prejudicial error occurred. There might be some indication there's some big issue they should take up, all those sorts of things. So in that case, it wouldn't be an allegation or a clear showing. It would be, I don't know, some other kind of indication that maybe we should get involved in this case.
Well, do you think number 6 should precede number 5? That might make it a little clearer that that's what you're talking about.
Sure.
So 6, can you go back down, Matt? I'm sorry. 6 is about,
But the petition has to contain reasons.
yeah. But then 5 is more about discretionary absent a petition. Is that the idea, Jeremy?
Right. In some systems, Yes. Yeah. I mean, the idea is that discretion could be exercised because of a petition or on the agency's own initiative, either or.
So in 4, I'm sorry to go back up. I'm just trying to look at flow here. 4D talks about on their own initiative. So does 5 flow from that, Jeremy? I've got 3 hands up now. Okay, let's go to Roxanne since she, yeah.
Why don't you go with Jeff or Jack? Because I might be making a slightly different
Okay.
point.
All right, okay, Jeff.
No, I think I've raised the problem, but I haven't solved it.
Okay, Jack.
Okay, so the question I have, which may lead to a possible solution is, do we think that the same considerations that the agency should take are also the kinds of considerations that that the petitioner should raise in their petition? Because if they are, then I think we need to combine them and combine 5 and 6 and say or 6. I can't remember the number. The end of 5. And maybe we start 6 with the last sentence of 5, and then have the list below that. You see what I'm saying?
So you would start with to avoid?
No,
That
I'm
line?
sorry. Go back up to circumstances in which first level review may be appropriate include when it is what I'm trying to say is, it seems to me that circumstances in which first level by a PSA official may be appropriate are the same considerations that a person may raise in their petition to get review by a PS official, right? When it's discretionary.
Same as an own motion review.
Yeah. So I'm not saying that it's for text in the recommendation. What I'm saying is we need I think Jeff is correct that that sentence, circumstances, whatever, should end with include claim that a claim claims that either claim the possibility that or something like that. And then
assertion.
no, I'm talking about in the end of the sentence of circumstances. You have to have something about the possibility that one of these conditions exists in order to make that work. That was Jeff's point.
Yeah.
Right? It has to be include the possibility that or something, because you don't know that until the decision is over.
Right. So I was thinking a colorable assertion that or something like that.
Yeah, maybe appropriate include color, include the possibility that. Something like that. And then in number 6, do we want to say that the petitions should raise the same arguments for discretionary review that the agency itself should consider for review on its own initiative? And so incorporate, so that A, B, C, and D are included in 6? Is that what we mean? Do we mean that? Or are there other reasons?
5 was meant to encompass grounds on which an agency might exercise review authority, whether because they receive a petition alleging one of these things in this list, or because an agency on its own motion has some sense that one of these things in this list is met. 6 is just intended to say that when you actually file a petition, you should explain why you think review is likely. So I mean, 5 is not meant to be restricted to own motion, but I think but I guess there's also a question like when you're actually filing a petition, should you actually cite one of these things above and explain why the circumstances are met? I think that seems reasonable.
Yeah.
Roxanne.
Can you scroll back as I up a little? I want to see what language has just been inserted. Include. Did we reject saying maybe appropriate if there are allegations that? Because typically for us, people allege the decision was erroneous or something was, you know, was wrong about the decision. And so this is just first level review. So basically you've got a lower level decision and then the PAS is the first level of quote review. Is that correct? What this is trying to get at, Jeremy?
So Jeremy,
Sorry, muted,
Yep.
yes. Lots of agencies also have own motion review authority.
Okay.
So it might not just be a petition. I mean, I guess one question is, do you think the grounds for granting a petition should be the same as the grounds for reviewing a case on an agency's own motion? If you assume it's the same list, which we've sort of done here, I think that the idea of 5 is that these circumstances would be appropriate, whether they're alleged in a petition or whether an agency has a sense on its own and decides to swoop in and review a case. If the grounds for granting a petition and exercising own motion review are different, then I think that would change the structure of the recommendation.
And the reason I originally raised my hand was a slightly different issue, which is that one of the things our agency does is we have an administrative law judge on unfair labor practices decide all the cases. The judge issues a decision. If no one appeals it, then the board just rubber stamps it. We issue an auto adopt is what we call it, because we're not going to review it if nobody asked for any sort of review. But there are certain circumstances, and it doesn't happen very often, but there's some circumstances where the parties to the case will agree amongst themselves that they don't have any material issues of fact. They agree on the facts. What they don't agree on is what the outcome should be. So in those circumstances, they can file what's called a motion for decision on stipulated facts or record. And so they apply to the board, who's normally an appellate body, apply to the board to make the decision of first impression. So they skip the ALJ process. And so it comes straight to the board for the decision. And in that case, there's no review level beyond that other than to go to a court. So I don't know if that's anything that you would want to throw in there as being appropriate, or if it's so unique to us that it just doesn't need to be mentioned.
I think, Jeremy, again, if it could be helpful to just clarify that, 4 lays out the events that a PAS might end up, the reasons why a PAS might end up participating. And then 5 is kind of building on that in terms of the types of problems or issues that might arise that might catch the attention of a PAS and or be brought to their attention by a petition. So it could be one or the other.
I think
And
there's one other important aspect of 4,
Yep.
which is it basically reaffirms a 1968 recommendation and a 1983 recommendation that you shouldn't have your ALJs or similar officers issue recommended decisions. You should have them issue decisions that become final unless some further action is taken. Now, the committee obviously can reassess the wisdom of that, but that was the recommendation made in the past. Obviously, in some cases, a statute might direct otherwise, but where agencies have discretion to direct lower level officials to issue decisions that become, or initial decisions that become final absent further action, they should do so. So, I mean, that's also a big part of 4.
Okay.
So
That's
the
helpful.
scenario that I threw out there actually would fit better under 4 than 5, it
Or
seems like.
maybe 3. It's a structural sort of thing.
Okay, and I'll just throw it out there, and Jeremy, if you and your folks decide it's something worth mentioning and fitting in somewhere, feel free. If not, if it's just sort of a weird aberration of our agency, feel free to ignore it. I just wanted to throw it out there as a situation where we have our PAS board make basically the first decision in cases.
Where there's no need for fact finding.
Right, exactly. The facts are all agreed to.
Okay, are we any closer to sorting out what we want to say here? I mean, we had left 4 alone, so I think the idea that Jeremy just explained is we want agencies to think closely about what events trigger participation by a PS. Otherwise, it's going to be a final decision, right? So these are the situations where it may be appropriate for the PAS to get involved. And then 5 is, well, okay, the PAS is going to get involved, and what are they able to do? And we say that they have discretion to review, decline review. They kind of, if they're going to be involved, they should be able to say exactly what that involvement is. And then we kind of get into something maybe a little different in terms of this list. And I do think whoever said there's overlap between what a PAS might consider in trying to decide, they've already been told they can be part of this process. So now, well, how am I going to be part of this process? What do I want to do? And these are the considerations we want them to take into account. And that may come from a petition, and it may come from their own reading of that decision. Jack.
Yeah, I mean, I think we need I'd like to hear from the consultants, whether my sense is correct that the factors listed in number 5 are the same factors that agencies ought to consider in deciding whether to grant a petition. And so, because I think that wasn't clear from all the number 6 said originally was that there should just be, that they should be able to petition, and there should be an explanation. But I think that but I think that the circumstances sentence that's at the end of that big paragraph at the beginning of 5 I think we don't want to say allegations, because it's not allegations, it's the agency's own view. So circumstances which first level review on a PSA official on the agency's own initiative may be appropriate, include the possibility that or a concern that and then we have the list, and then in number 6 we say the grounds for review or something like that. I'm not trying to draft right now. I'm just trying to give the thought, and then that the grounds for review should include those considerations in 5, and then any other considerations that the agency deems appropriate or something like that. Because we don't mean to say that the agency should limit discretionary review to the list in number 5, but I think we want to say that certainly if those are reasons why the agency ought to do it on its own, it's also the circumstance under which people ought to be able to petition to get the agency to do it. Does that make sense to the consultants in terms of what we're trying to, in terms of what's in the, what the point is of this?
Yeah. I think it's a slight restructuring, but I think that makes sense.
So we could retain 6 and maybe add to it that the explanation in the petition could raise the same, or, I don't know, is it should? It could be other reasons. I think that's what I heard you say, Jack. It could be those reasons.
Raise
It could
the
be
same
other
arguments.
reasons.
The petition should the discretionary, it seems to me like period file petition requesting the PSA review is discretionary. The agency should the petitioners should
The explanations should.
Yeah, the explanation should include. The explanation may include the same factors. The factors that may lead an agency to grant review on its own initiative, and any other factors the agency specifies. I think the agency ought to be responsible for specifying the grounds for this review, right?
Yes.
I think I hear you saying the explanation may include the same arguments or the same, I don't know if
May
is it
include the
arguments?
same reasons is included in paragraph 5, the same
Or
reasons
any, yeah.
included in paragraph 5, um, uh, uh, the same reasons that call for review on the agency's own initiative is included in paragraph 5.
So they include the same.
For review on the agency's own initiative, after the word reasons, it may include the same reasons for review on the agency's own initiative, as included in paragraph 5, and any other grounds the agency may may determine are relevant to the decision to grant discretionary review.
I think that's a start.
Something like that.
Yeah.
That's I'm not sure that's drafted properly, but I
Yeah,
think that's the thought.
I think it's a start.
And I actually have to leave in about now to go to a faculty meeting online. So I appreciate everyone's bearing with me on my overly verbal whatever. Okay.
Thank you, Jack. We'll see you next time, hopefully. Well, before we leave this point, any comments or thoughts about, I mean, Committee on Style can kind of massage this and maybe take a fresh look at whether we're totally off the rails here. Jeff?
Just a quick thing, maybe the explanation may invoke the same reasons.
Mm-hmm.
Now I also want to go back to 5 if that's
Sure.
your
Let's do
main.
that. Yep.
Few stylistic things here, which I don't know. If in B, for example, why not say, I mean, all of these say, uses the term which a lot. So I think if we said in B, the lower level decision embodies an erroneous or clearly erroneous finding or conclusion of material fact, make them adjectives up there. And then C would be similar, embodies an erroneous legal conclusion. And D embodies an important exercise of discretion or decision of law or policy. Just to sort of shorten it a little bit. So then I also have a thought on the next paragraph that maybe belongs in a separate number paragraph, because it's kind of a different point, this to avoid multi-level review. So I guess one of the points there is that the B subsection also has the same problem as the earlier thing, where it's kind of a fait accompli. It should be limited to circumstances in which the first level reviewer erroneously interpreted the law. Well, they don't know that until they've looked at it. But so in which there's an allegation, it's the same issue. But also, I think that Roxanne's point kind of fits into this little section here, because this little section talks about what PAS officials should be doing with respect to purely factual issues. So we're making the point here that there shouldn't be second level review of factual level issues by a PAS official, but we could also say that in some circumstances it's appropriate for the PAS official to be involved in a case where there are no purely factual issues or something. If we look at this little section as involving questions of review of factual issues, maybe we could separate it into another number and then get Roxanne's point in there somehow.
Matt, I think this language Jeff is referring to adding to the to avoid piece. Yeah, I think that's
Yeah.
And that it would be a separate, it would be a separately numbered Is that what you're thinking, Jeff?
Yeah, separately numbered, maybe not.
The to avoid, that whole little mini section there
Yeah,
that's
yeah.
under 5, yeah.
Yeah,
So we give
maybe,
that a number. Oh, I hate that form. How
Yeah.
did you get that to do that, Matt? You could teach me that little trick.
yeah, and I think I might want to put it after what's now 7, switch it with 7, but. So. It's a little hard to cram both thoughts into this new number. New number 7, but it's related. It seems to be related to Roxanne's point, because here we're saying, when we're talking about purely factual issues, we don't want second level review by a PAS official, except in these 2 little exceptions. But we also recognize that there might be cases where we want a PAS official to be making the first level decision if the parties agree that there's no factual issue. So I'm trying to get Roxanne's point in here somehow. But it may require more drafting. I don't think it just necessarily fits into C. It may be.
Jeremy,
Would you want to put it in 1, the paragraph 1 at the top, which talks about initial proceedings?
Roxanne's point?
Yeah.
Yeah, maybe.
Basically, when
Oh.
would you want to step as a PAS official? When would you want to step in for an initial decision maker? And this might be an example of when it might be good to do that.
Roxanne?
Oops, so thinking about it more, since this is best practices. And personally, I've never really understood why we allow people to put things before the board strictly on the record if they all agree to the facts, because it doesn't speed anything up. It's a lot of work for the board to be doing that initial decision. You know, maybe it isn't the best practice. Andy and Fred might want to shoot me for saying that, but I've often wondered why anyone would do that, because it sure slows things down to try to have the board do the initial decision as opposed to reviewing what someone else has already decided. So I'll just throw that out there.
But it's just a legal question at that point, isn't it?
Yeah, it's purely a legal question because everyone's agreed on the facts. It's just, okay, how should these facts apply to the law? And normally an ALJ would make that decision, but the ALJ would also be finding the facts and then applying it to the law. Here you skip the fact finding part and have the board just
You
simply
skip
apply
the
it to the law.
application. You skip the application to the law part. That's the.
Yes.
Yeah.
And that's very helpful when an ALJ has applied the law.
Right.
Sometimes they
So-
don't apply it properly and the board can correct that on appeal, but you
Maybe
miss out
I'd
on the
ask-
benefit.
Maybe I'd ask Nadine whether OSHRC does something like this.
We allow the parties to submit a case on stipulated facts, but they can do that before the judge, the ALJ.
Not the commission.
Usually, yeah, by the time it gets to us, it's still on, right? As an initial matter, it happens before the judge. That's helpful. It does not come to us directly. It would always flow through the judge.
So maybe it's not. So I guess Roxanne's saying maybe it's not a best practice.
Yes, I'm admitting it may not be a best practice.
Okay.
So maybe not worth trying to capture, I guess.
Yeah.
Yeah,
What you-
don't knock yourselves out trying to fit that in somewhere.
All right. Well, then if we go back to that language in the new 7, I think it is sufficiently different from.
Yeah, I think we just created this as a separate, we pulled it out of 5 and made it its own standalone, which I don't think is necessarily a bad idea, but we haven't made any changes to that at this point.
Yeah.
It's,
So now the only problem I have with it is 7B. We have to do the same thing we did with the previous section that indicates that there's been an allegation that the first level reviewer, I mean, it's the same problem we sort of solved before. See what I mean?
Trying to find where we solved it.
I think we used a concern.
Include a
Yes,
concern,
thanks.
a concern, yeah.
And
Right.
would that term adequately capture, you think, the sort of an allegation by a party or some other indication?
Maybe
May
we say
have.
there
And
was
what
an
I'm thinking more
allegation.
is, so, I mean, you have some sort of quality assurance system set
How
up,
about-
right? Where there might
how
be a
about-
dedicated staff who like reviews cases and said, ooh, maybe this might be good for an official to review.
Yeah, how about may have,
Match.
may have erroneously?
Yeah.
Yeah, okay.
Okay,
Now, we went over those other style changes I made pretty quickly. I don't know if everybody agreed with them, but you know,
yeah, the ones in the list on 5,
yeah,
I think they're fine. Anytime we can streamline, I think.
get
is
rid of
good.
witches.
Yes, I agree.
Those were taken nearly verbatim from recommendation 83.3, Jeff, so I will defer to you on whether this is better.
Yeah, I guess I was there then, but I wasn't well.
Uh,
okay,
and you know, time passes,
I'm
things look
kidding.
differently.
That was before I knew the difference between which and that, I think.
There we go.
All right, I think we can move forward to 8.
New 8.
New 8, yeah, okay.
Old 7. Or
Yes, new 8. Anything on new 8? Deemed denied, love that phrase, deemed denied. Anything on 8, new 9? Oh, we have a Russell, thank you. Russell, did you have anything? I don't know if he's still.
I'm here.
He's good, okay, good.
No,
Um,
just
yeah.
the active voice are permitted. Who's doing the permitting?
Ah,
When blank permits,
when
I
the
just don't know who's-
agency, the
Is it-
agency permits?
is it the agency or an individual decision maker or what? Agency rules? Okay. I
To
think
file.
there's another one of them somewhere. Other. Yeah.
Thank you, Matt. That's great. All right. So anything on 8 or 9?
I do have one thing, sorry.
Of course, Jen.
Do
Yeah.
we want to, should we consider removing should consider from 8
You're singing
and 9?
you're singing to the choir, in the Andy choir. Should provide. Any thoughts?
I think the 1 in 9's okay. Because we're telling them that they should.
Yeah.
Look over them. You know?
$1971. That's amazing that we're citing to it now. It's great. Okay, anything further? All right, so we can move to procedures. Why don't we take a 5-minute break? Nah, 10 minute break. 5 is too short, isn't it? It's not really a break. 10-minute break, and then we can tackle the procedures for review. I think we earned it. We have another hour, right? 5:30. So we're gonna go into the happy hour. But we'll come back refreshed and we'll start on 10. Okay, 10 minutes. See you back here. Okay. I think we're good. It's been enough. Hopefully everybody grabbed some sustenance for the last 45 minutes, 50 minutes. Let's get started with Matt, I can't see Matt. Matt is there. Okay. Let's make sure you're ready for us. So let's start with 10. Any comments about 10? Can I just ask, Jeff, did you have something? I see your hands up, sorry. No, okay. I was just gonna ask something of Jeremy and or Jen, is the idea that this would only be done if they do it on their own motion.
By means of something other than a petition. So it could also be a lower level adjudicator, say certifies a case, or there's some programs where so like in the immigration system, the Secretary of Homeland Security can actually directly refer a case to the AG for review. So in cases where a PAS official is taking some action based on something other than a petition, you have to notify the parties and
Okay,
be transparent about it. That's the idea.
okay. Okay. My only thought in some of these, and it may be an unfounded concern, is that is the PAS official themselves as opposed to it's them directly. It's not an admin, it's not a clerk of court, it's not, it's the idea is that it's the official themselves. I'm just thinking purely from a mechanical functional standpoint.
I don't think we were thinking that it would have to
Okay.
be the PAS official themselves. I mean, frankly, mailing a letter, preparing a letter, that's the exact kind of thing you should delegate.
Delegate.
So I mean, we sort of get at that. We get at that idea in paragraph 18.
Okay.
But certainly in looking at this language, we did not necessarily mean that this should be specific. Maybe some of these, I mean, maybe like the actual mailing of the notice, no, but in terms of providing a brief statement or providing the parties a reason, I don't know, some of that maybe it's going to be, I think, a case by case determination, or program by program determination, but we did not mean to say that support staff can't be involved.
I think you answered my question with 18. I forgot about 18. Thank you. Roxanne?
Could we simply change the language? So instead of saying the PAS officials should notify the parties, maybe just as the agency should, or then the parties should be notified, or I just think it doesn't have to specify that's the PAS doing that. I know, Jeremy, you're right. Realistically, they're not going to do that. That's going to be a ministerial function. But I think we could just simply say the agency should notify the parties, provide a brief statement of the grounds, blah, 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 blah. Yeah, something like that. That would
So
work.
should it be provide a brief statement of the grounds for the PAS official taking such act, because it's not the agency in that sense,
I
right?
would say for the action.
Okay, that's better. Yep.
Yeah.
That's better. Any thoughts, objections there? I think we have the same issue maybe in 11. PAS official who grants a petition for review ordinarily should notify all the parties.
Could it say the parties to the case should be notified and provided a reasonable time to respond?
So we'd have to restore when?
Yeah, I guess so.
I mean, we could use the agency again there. If we wanted to. The agency.
That's true. We
yeah.
can do it the agency, or we can just simply state it as parties should be notified and provided time to file responses, whatever works best.
Don't forget Jack's comment.
Oh, that's at the, okay. Um,
He's basically saying maybe they should allow that before he decides to grant the review.
I mean, that is a good point in that the way our procedure works is that if an administrative law judge decision issues, if one party files exceptions, meaning that's the way we call it when someone's asking for review. If someone files exceptions, then we give additional time for the other parties to file cross exceptions.
mhm,
But again, they're filing it before anything is granted.
mhm.
But we give extra time because on the thought that one party might want to make some exceptions, but they don't feel so strongly about it that they're going to be the first ones out of the gate with exceptions. And if the other side doesn't file exceptions, they'll just accept it the way it is. And so that's the idea of the counter petition, but we have that filed before review is granted. So exceptions are filed, then somebody has more time to file cross exceptions. But I think Jack makes an interesting point.
But you don't do anything special after the petition's been granted.
If we grant review, which would be a different type of action, but that's
Mhm.
okay. If we grant review, then we invite all the parties to file briefs on
Briefs,
review usually.
Regular briefs, yeah.
But I've never seen anything like a counter petition at that point in time. Because I think he's right, it's kind of a little late to be filing a counter petition for review if review has already been granted.
Jeremy or Jen, could you speak to and provide them a reasonable time to respond to the petition or file a counter petition?
Yeah, that's a mistake on my part. Jack's absolutely correct. Counter petition would proceed granting a petition as opposed to follow it. So we can
So
certainly
should we strike the or file?
probably.
Yeah.
I mean, I don't know if you want to separately address the idea of a counter petition, but I don't know that it's necessary. Really, we meant just a time to respond.
But would the time to respond also precede the granting?
Yes, I think if you want to have a separate recommendation about counter petitions, which may be useful, especially since reviewing officials often limit the issues they'll consider on review to things raised in petitions. We can certainly take a stab at drafting a recommendation that deals with the idea of counter petitions.
I was referring to the language that's still there, which is, and provide them a reasonable time to respond to the petition. So
I probably submit, I meant respond to the ideas in the, but you could say submit arguments, I think is probably fine.
okay,
We call it, if it's
And that
helpful,
all-
Jeremy, we call it briefs on review, because
Yeah.
basically the board's granted review and they're going to review it.
now we
And we
want to
let
hear from
parties
you.
file briefs on review. Because when somebody files a petition for review, other parties can file an opposition to that or
Right.
answer of some sort.
Right.
And that's all considered when they're deciding whether or not to
Prior,
grant
mhm,
review.
prior to granting.
Yeah, and then once we grant, then we may invite the parties to file briefs on review.
Right. Yep. Yep, exactly.
Which we've also said in 10. I mean, it's kind of the same opportunity that we're giving at the end of 10 there, providing the parties a reasonable time to submit written arguments.
Well, 10 is where there is no
On
petition.
motion.
Yeah.
I know, but still,
It's overlap.
you're providing the parties to reasonable time to submit written arguments. And here, we're providing them a reasonable time to submit arguments.
Yeah, the only difference between 10 and 11 is the provide a brief statement of the grounds for the action.
And the written doesn't say written either. In 11.
Right.
But then later, in 13, there's the oral argument possibility. The new 13. So that maybe that should, I mean, I think we can sort of mesh 10, 11, and 13 somehow a little bit better, maybe.
Yeah, maybe it could be rewritten video style with like some just sub bullet points, like when this happens, then this first is the discretion review, then when review is granted, and then somewhere fit in oral argument, just sort of like some sub points as opposed to separate paragraphs. Would that make sense, Jeffrey?
I think so.
AS official is going to review a decision under any circumstance on their own motion, upon referral, granting a petition. I mean, those are all of the scenarios that pull the case in. This is what we, yeah.
I'm sorry.
Go ahead, Jen. No, please.
Do we think that there are different considerations for when a PAS official exercises discretion as opposed to responds to a petition? Because if we do, then I mean, so this discussion is assuming that all the considerations are the same, the procedures that follow should be the same. But if there's a reason to treat them differently, and I don't know if there is.
Yes. I hear what you're saying, Jen. That's why I think the difference between 10 and 11 is this provide a brief statement of the grounds for taking action. Because if you have a petition, it's obvious why you took the action. You believe in the merits of the petition. But when you're bringing it in on your own motion or it's upon referral, then, you know, so the parties might want to know why. In our agency, the why comes in the form usually of a briefing notice where we signal exactly what we want them to brief. So it's clear to them that's why we brought this case in. Yeah, I don't know. I hear what you're saying. Do we think that the
It
considerations
could
are
be
the
written
same?
more economically, I think, you know,
Yeah.
if we follow
Yeah.
The idea that, you know, well,
Yeah, you want to notify the parties. You want to give them time to submit arguments. And if it's
they
novel,
Yeah, thanks for pointing that out, Jennifer. And I think at the end of I think the outcome here is we want to make it clear that let the parties know what they should be arguing about. In other words, if you just say, we're going to review this, and you don't give the grounds for it, as Nadine said, that would leave the parties floundering and just trying to guess at what they should be briefing. And that's not
wasting our time when
Yes.
it's not stuff we're interested in, right?
Yes.
Okay. I think our suggestion is to leave this to committee on style. I think there's a way to meld these things. So I think we're talking 10, 11, and I think we mentioned 13.
I mean, the only question is whether 13 and 14 should be moved ahead of 12, but
Can we scroll down to because I'm looking at hard copy and I realize I'm looking at the wrong numbers. Yes, oral argument and amicus. Okay. Those might be, well, any thoughts on those?
I think oral argument could be fit into the mix in terms of that would just be one decision point in terms of what sort of argument are we going to allow the parties to make? Is it all going to be in writing? Are we going to grant oral argument? So I think that could be fit into this new structure that just says we're letting the parties respond to whatever it is we're doing. And so one of the points could be they decide whether they're going to invite or allow oral argument.
but 13 and 14 have to do with the decisional phase, not the whether to grant or whether to grant review phase. I don't know if you want to have, I mean, you've only limited to written arguments on the whether to grant review.
No, I think these
So-
are these
This-
are after, right?
Well,
Can we go back up? Sorry, Matt, to the. So 10 and 11 both assume review is granted, right? Well, review is happening. And in 10, they're pulling it in on their own motion or they're being referred to it. It's coming in. The case is coming in 10, and it's also coming in 11. So it's not considerations for deciding whether to take review. It's review is it's going to happen, and what happens after we grant,
well, except
I'm
that
not being-
11, according to Jack's concern was that the argument should be allowed before the decision to grant a petition for review has been made, right?
But I think that would be in the prior section on initiating review. Some of the considerations that might play into a decision to take a case
I'm not sure. about-
versus what
Yeah.
happens after the case has been designated for review.
What do we say about initiation? Procedures?
So it was 6. I don't think it's 6 anymore. It might be, so it's 5.
Yeah, there's sort of a chronological little gap here about
Yeah.
whether or not there should be availability of counter petitions or
Yeah, I think 6 is where to
Opposition.
put it.
opposition to
is-
petitions. Yeah,
6 is where to put it.
Yes.
the old,
When agency rules permit parties to file a petition, we want you to explain why review is warranted. Here's what that explanation could say. And then I think the idea is also agency rules,
Should allow
yeah,
other
For-
parties.
yeah. For parties to respond to the petition or file a counter, yeah.
Yeah.
Or file a counter, I mean, yeah. I mean, they could oppose it or they could file a counter, right?
Yes, I think that fits better there, or fits well there.
Okay,
Thanks, Jeffrey. You're right. That was where Jack was trying to make sure that there was some opportunity for response before the review is even granted, and that would
right.
Right.
should do it.
Okay, so we're back to, I think we've got the comment here about meshing 10, 11, and 13. Do we want not, sorry, I'm losing track of my numbers, the oral argument one to also be meshed?
the new 13.
Thank you. All right, so then 14 maybe. Did we think 14 by including amicus participation should be separate or part of that whole?
I think
List.
that should be separate. I think the oral argument should be a part of what the agency provides to the parties.
Okay,
And then 14, which is you're asking for the public to weigh in. I think
Mhm.
that could be a separate,
Separate.
not part of all the bullet points, because that's
okay,
if you decide, okay, this is important enough that we want the world to give us their opinion.
got it. And then I think we need to deal with 12 because 12 is kind of in the middle of all of this. Matt, do you think we have enough here on Committee on Staff for 10, 11, and 13? enough
Sure, it shouldn't be a
guidance.
problem. We discussed structuring some of this in a similar fashion when we were
Okay,
putting this
fantastic.
together the way it was.
Music to my ears, thank you.
But I'm still wondering whether there's a difference between the procedures we're offering in I'm forgetting the numbers now. The ones that if you move up a little bit, 10 and 11, I guess. So yeah, 10 and 11. These are procedures that sort of are right at the point when he's granted a petition for review, whether it's or own motion review. So he's allowing some arguments to be made at that point. But then farther down, when we're talking about oral argument, we're talking about assisting the PAS official in deciding a matter in a fair, accurate, consistent, efficient, and timely manner. It seems like chronologically it's slightly different there. That's kind of a decision of the whole case there, you know, the briefs and oral argument and whatever. But the stuff in 10 and 11 were sort of a little more preliminary, it seems to me, at least the way it's worded now. I don't know if Jeremy has a thought on that.
I mean, to me, 10 and 11 are the things that should just happen in every case. Whereas once you're talking about 13, 14, you're saying should be certain special circumstances in the case that say warrant oral argument or warrant public participation of some type.
So it's all the decisional phase of the case we're talking about here.
Yeah.
To be honest, Jeff, I read it the same way you did.
Yeah.
In that the 10 and 11 were, we need the decision to review, and then later on was like essentially the merits, like what happens when you're deciding.
The merits, yeah.
Yeah.
No,
Yeah.
that makes sense. I know I was one of the proponents for sticking the oral argument in with the other, but you're right. I mean, Jeremy's explanation I got it through, which is not every case is going to require that. It would be the more complicated cases where someone might decide we want to grant oral argument here. So that would be the additional things.
I guess what threw me off was the language deciding a matter in a fair, accurate, consistent, efficient, and timely manner. It should be manner, I guess there, not matter, but the second matter should be manner.
A manner, yeah.
Yeah, but we throw that in there as if it's like the merits, you know, the merits decision, but we don't have that same language any earlier.
I
What
was
if-
reading it as all post the decision is in the door. What happens? What's the procedure? How's the case handled once the decision has walked through the door?
Well, do we need all of that? Could we just say would assist the PAS officials in deciding the matter, period?
It seems like we're have too much detail.
But we had included this because there's obviously lots of ways to get information. Oral argument can be a sort of expensive and time-consuming way to get it. Not always. Sometimes it's actually more efficient. So it was the idea that you should actually do this if this would actually improve accuracy, efficiency, all these sorts of things.
But there are only two stages here. We're talking about first whether to grant review. That's one stage where there might be some procedure, and then once review is granted, then we have the merits case, and there's various ways of proceeding under that.
Right. You could have responsive briefing if you want, or if you think that oral argument, bringing everybody to say, I don't know, put them on a Zoom call, bring them all to Washington is more effective or efficient or whatever, do that instead. The idea is figure out the best way to get the information that you think you need once you're trying to figure out the merits of a case.
It seems like
the ideas don't reflexively grant motions for oral argument unless you think oral argument is actually a useful.
Yeah, but this is all under the heading of procedures for review by PAS officials. So then there can be kind of two parts to that. For the first part is the should the door be open? And the second part is, once the door is open, this is what happens.
But I think the should the door be open part is in the prior section, the initiating review section.
To me, 10 and 11 are like basic case intake type stuff. Whereas as we start getting further down, you start getting into special cases where you may want to have sort of supplemental procedures because there's a really important issue or because something's broadly consequential. But wouldn't be dealt with, say, by staff at case intake.
Well, I think that reconfiguring 10 and 11 into this sort of bullet point thing keeps that sort of spirit, which is, here's what everyone's should be entitled to, which is the ability to put forth their arguments in writing when their case is going to be reviewed. But then separately, if the PAS thinks it would help to have oral argument, they can grant oral argument. So that would be separately. I don't think people are going to reflexively do it too often because it is expensive and time consuming and blah, blah, blah. And we do it one every however many years. We don't do it very often at all, even though we have the ability and they would do it if they thought it would help with their decision making. And for the most part, they think the papers are just fine.
Well, okay, but if you look at number 11 that's on the screen now, it just says when petition has been granted, parties should be notified and they should have a chance to submit arguments. Well, of course they should have a chance to submit arguments. The case has now been accepted for review. So, you know, there's going to be a big proceeding now, you know, but so that almost doesn't say anything, or it's not necessary to say what it's saying that like that, because it used to say or file a counter petition, and when it said or file a counter petition, then it seemed like, well, we're still at the stage of whether and how to grant the petition, and maybe we should see a counter petition. Maybe the petition, you know, should be granted in a different way. That was a kind of like still a door opening stage, it seems to me. I agree with Nadine that a lot of the door opening stages in the prior section now, but
I like that metaphor, door opening.
so now, but now you took out the counter petition phrase in number 11 there, so it doesn't really talk about that, but it just doesn't seem, it seems like we're saying, if all we're talking about under this procedure is how the case should go forward after the petition has been granted, that should be a lot simpler to draft than all of these sections.
Yeah, and I think they're going to take a crack at combining 10 and 11 into a much more succinct statement.
I will say one thing, some of this can feel really simplistic, but I think a lot of this already happens in all of the sort of big high profile programs that we're familiar with, especially at sort of independent agencies where PAS officials rarely engage in adjudication. A lot of this tends to be far less routinized in other programs. And it actually, this is the sort of stuff like you took on motion
bolts.
of my case. And like the first time I heard about it was when I received a decision in the mail.
Yep.
So even just specifying basic routine steps may not make one bit of difference for independent agencies that have been doing this since they were first established.
Yeah.
It might make quite a bit of difference for a program in an executive department that's not quite so routinized.
On this point, in doing one of my case studies, I actually reached out to a couple of people who practiced in a particular area, and they were like, there are procedures. Has anybody written on this? I was like, well, I was kind of
My
hoping
goodness.
you could tell me. So
No, I think it's important to lay these out. It is kind of second nature for maybe Roxanne and I.
I guess
But-
if we're only thinking about the formal APA adjudication model with ALJs, then it doesn't seem necessary to say all this, but we're not, I guess. That's Jeremy's point.
I like the idea of meshing these, you know, the idea is once the case is in the door, however it got there, these are the best practices you should follow. You should let the parties know, give them a chance to respond and submit arguments. And then maybe in the unique circumstance where you need oral arguments, you should be allowed to do that. I think we still have 12 as an outlier, not to jump ahead, but 12 seems like it's out of place right now. Because it seems decisional. I think Jeff has been using that as kind of maybe a just distinguishing feature between what we're trying to lay out here. So the case walks in the door and what happens right after it walks in the door, and then when you get to the merits, 12 seems to go to that, right? The
But it-
nitty gritty of
But
deciding.
in 12, we have this opening line, when a PS official reviews the decision, or a PS official who reviews a decision of a low level adjudicator should do all these things, but we don't repeat that phrase in the following recommendations, even though I think it's assumed or implied. Right? Oral argument part and all these other parts, we're still talking about the same.
Yeah, I think it should come later. Maybe that,
But that's almost like an opening sentence or sentence fragment for all these things that follow. We're talking about a PS official reviewing the decision of a lower level adjudicator. Aren't we?
Jeremy is nodding.
Yeah, I don't think we meant anything specific by including this here and not in other paragraphs around it. It was
Yeah.
just an opening line of this paragraph. I wouldn't
Of
take
this,
it.
of this paragraph, but it should
Yeah.
be, yeah. Right, so it's an organizational issue, how to
Right.
do that. Although it doesn't cover Roxanne's example where they're not reviewing the decision of a lower level adjudicator, but we're not going to talk about that.
I think that would be
Yeah.
best. I mean, if you want to have it, I think organizationally that would fit best in paragraph 1, but we won't talk about it.
Well, I think we're going to leave to Committee on Staff to kind of reorganize this section. And maybe see if 12 needs to move somewhere after it's been restructured. I think it may
One thing
reveal
about-
itself.
On 12, where it says in such context, maybe it should say in such situations. Second, yeah, right there.
I think this gets us down then to the last one in this section, which is about the ethics considerations. I think we've kind of touched every other paragraph in this section, and we'll see how it reorganizes. Committee on Staff is going to do a bang up job on that. 15, any thoughts on 15?
Seems broader than the previous ones because we're talking
Mhm.
about any kind of participation in adjudication. Maybe it should be a separate, maybe.
Yeah, I thought the same. I wasn't sure if it fit here. I'm not sure where it fits, or if it's its own section, or it goes all the way at the end. I don't know. Any thoughts? No, we're winding down last 15.
I don't think it has, there's no problem with what it says, just where should it go?
Absolutely, I agree. Matt, maybe we just put a comment in and see if we can, I mean, it's either like a standalone section or it becomes part of another section that maybe it goes all the way at the beginning. I don't know. Maybe it goes all the way at the beginning. Thanks. And my dream of getting through the recommendation at least once today is fading fast, but that's okay.
I don't think the
Uh,
next two are very
Yeah.
complicated.
So coordination, thank you, Jeff, I love it, the optimism. Coordination of policymaking, 16 and 17. Anything on these sections?
We said them before, basically.
Mhm. I wasn't thrilled about the policymaking word because it's not what my agency does, but I think it's fine.
Well, I
Mm.
guess, yeah, you're number 17, you would never do that, right?
Right.
Where appropriate, or.
Yeah, no, it's fine.
It's a coordination of policymaking or decision-making by lower level adjudicators. I mean, that's
Yeah,
really the
yeah.
idea. You're either developing policy or you're sort of fostering consistency.
Ooh, I like that. Yeah.
Well, you could
Well, we
change
can,
or other general policy making by the agency at the end. Make it a little more specific to an agency like OSHA. Does the commission ever issue guidance to the ALJs on everything?
no.
Hmm.
We speak to them through our decisions, that's it.
So,
Ditto.
Okay. Adjudicative support for a PAS official.
I don't like this assume the burden. It sounds,
Oh, Jeff, you're singing.
it sounds like,
I don't like it either.
No one
But
does, don't worry.
you know where it comes from, right? It's in the report. It's from that Attorney General Joint Commit. What was it? I'm not.
It's from the 1941 report of the Attorney General's Committee. So I can't claim, you have to blame Walter
Yeah, I was
Gelfand
just
to
gonna
underscore
say,
it.
you need to be clear that this is not your language.
now how about take personal responsibility for?
I think that's fine.
Any objections to that? I like that much better. Jack, you're back.
Yeah, I'm back. I went to another meeting and I'm back already. We
Yeah,
granted
well,
8 people
you
tenure.
refereed a game, you went to
Yeah.
a meeting, like you just
We just granted 8
multitask.
people. We just granted 8 people tenure and fired 4 people. I'm
Oh
just
my
kidding.
Lord.
So, is participation the same as synonymous with deciding?
It's a good question.
I mean, because if they're, I mean, the obvious leads to a question. If they were involved in it but didn't actually make the decision, I'm not sure what personal responsibility for their. I mean, what does that mean? Do you mean that they should publicly be identified as the one who did it? I mean, I'm not sure. There was an agency in Illinois where the ALJs were basically the head of the agency would look over the shoulder of the ALJs and make sure before they issue their decision that it was the decision the head of the agency would reach, so that she could affirm all their decisions.
Wow.
That was a pretty powerful deposition when we sued her over it. But I'm not sure what you mean by take personal responsibility and whether participation means they decided. I mean, do you mean they should publicly disclose that they're the one who decided it? I'm not sure what this sentence means actually, as I look at it now.
I mean, I agree with that. I mean, I just trying to improve the language, but I agree with your point. I mean, it's an accountability point that you're trying to make here.
Yes. Yeah. I mean, this language clearly came out of, look, it came from 1941. It was clearly in response to the Morgan cases, where you basically had the concern is you don't want an agency head like rubber stamping stuff saying, yeah, this is my decision. But in fact, a whole bunch of lower level staff are actually doing it. Of course, there's lots of stuff lower level staff should do, which the committee also said. The idea is that like the actual decision making at the end of the day should be done by the person whose name appears at the bottom of the decision.
So it's
That's the
decision,
general
not
idea.
participate.
What if it said it decides instead of participates?
I think
Yes.
that's great.
Yes. Peter.
Thanks. I just had a concern. We talk a lot of times about PAS officials acting in their official capacity, and then there are times they may do things in their personal capacity. This comes a lot of times on the ethics world. I'm a little worried about what we mean by personal capacity. Are we saying they would be personally held responsible in their individual capacity, as opposed to, would this be the acting Secretary of Labor when she signs a decision, or would we say, no, that's Julie Sue? So I just worry when we talk about, we have that word personal in there, because in different contexts in the federal sector, that could have different meanings. And I don't think the idea is we're going to hold them personally responsible as opposed to officially responsible. So I struggle for different reasons, the same as Jack Bierman, just understanding what's meant here.
Yeah, I've got to be honest with you. I did not like the language from 1941. And my gut reaction to it when I read it is a PAS official should do their job. They should do their job. They should do the work that is expected of them. And I don't know how we say that in a way. Maybe that goes without saying, but maybe it needs to be said. You can't foist this off on somebody else. This is your job to make this decision.
Well, are we just saying that the person who's actually making the decision should be known? I mean, it should be publicly, it should be signed, it should be.
I think that's part of it. I think the other idea is that if your name appears at the bottom of the thing, make sure you're the one who's actually making the decision, as opposed to sort of letting staff make decisions and you rubber stamp it at the
Absolutely.
end.
I agree.
That I think was the committee's concern.
Is
Yeah.
part of it then an acknowledgement that they are the official decision maker? There should be some acknowledgement that the PAS is the decision
I think
maker.
it's more than that, Jeremy, right?
Yeah,
That they
yeah.
are, in fact,
Deciding the case, right? Like,
yes.
I don't know. And maybe there's no real clean way to say this, but the
Yeah.
idea is that you're not saying
just-
reviewing a case, delegating every part
decision.
of the case to somebody else, and
And then signing it.
your name. Yeah.
Yeah. Jack.
So I just want to understand what the evil here is. And let me just like throw a hypothetical. Suppose you have a person who basically, they're supposed to decide a case. They get the briefs, they have their staff write them, read the briefs, do the research. They have the staff write a decision, and the PAS person gets a one-page summary of the whole thing with a recommendation of what to do. And all the PAS person does is read the one page, and then they sign the opinion. Is that what we're trying to say they shouldn't be doing, or is that perfectly appropriate given all the demands on their time and energy?
I think reasonable minds will differ.
I know, but
I
what are
think
we
it's
trying
probably-
to say? That's what I'm trying to figure out.
I think some people would have a real problem with that. And I think, obviously, I don't want to cite the Morgan cases because that was a weird instance in the 30s, and it's probably not worth hearkening back to that. But I think that it would certainly be a concern where it's like, okay, if I'm subject to removal and the Attorney General takes my case from BIA, reverses a decision in my favor, it's signed by the AG, who actually participated in that decision making, who actually made that decision. Was it the AG? I don't know. That's at least the concern that's been sort of raised in various systems over the years. The idea is that the person who's saying they should be making the decision should really be calling the shots in a sort of supervisory sense. But
okay, I understand that. And calling the shots in a supervisory sense, I think, is consistent with what I said. The hypothetical I gave. I mean, do you think Jeff Sessions actually read all the briefs and decided those immigration cases? I think probably not. But on the other hand, he was 100% responsible and politically accountable for the decisions that he made. Whether you agree with the decisions or not. I mean, I don't think anyone had any doubt that it was his handiwork and that he was completely responsible for it. What I'm trying to say is, are we saying he shouldn't? Are we trying to make a recommendation that says that that's not proper? And and if not, I'm not sure that this is even a necessary. I mean, if the PA, I mean, is basically the idea is like that the person who makes the decision should be named? Do you think that that all the people that participated need to be named? I don't think so. I mean, federal judges don't name their law clerks in their decisions.
I think we should take this out. And I say that because it doesn't fit under the heading that's up there. It has nothing to do with the adjudicative support. And 19 implies that other functions do require the personal attention by a PAS official. So it's we're sort of saying indirectly that, we expect the PAS official to give personal attention to things, but here's some things they don't have to get personal attention to.
So do we
Actually-
delete it?
Actually thought about 19 being the agency should not delegate functions that require personal attention but then we're right back where we started, which is,
But
what are
may-
those?
But may delegate these.
Yes.
Yeah, I mean, that's
So
the real
Jack-
question. That's the real question is when a PAS official is involved in reviewing a case.
Yeah.
What functions, if any, do you think should absolutely not be
Yeah.
delegated?
Very helpful. Matt, yes. Matt.
I just want to say I agree with Jeff and Jack. I would strike 18. I think it's just sort of, I think there's a lot of trouble afoot there.
We do not want that. Peter is giving it a thumbs up.
Yeah, I would agree to, with the more learned minds in mind of just getting rid of it.
I'm gonna go with, it goes without saying that you're doing your job. Jack,
Would it be helpful just to write before the beginning of 18, to just write something in there saying when PAS official decide in cases that are decided by a PAS official, agencies may delegate routine functions that do not, or should, if we think should.
Yeah.
Like something like that. By between by and PAS, maybe you want to put a by a PAS officials.
Yeah.
But maybe that, just so it's clear what we're talking about here.
That works.
Does that
That's
help
fine.
I like that
That helps.
maintain a kernel of what is in 17?
Yeah.
point of emphasis. Yep, I like it. Yeah, we need an A after by. Yep. Yep. Okay, I think we have time. Can we?
Can we change the second A to a the? Or person by the PAS official?
Yeah. Okay, do we have time? Russell, do you have comment on the list here about?
Well,
Yeah.
I mean, I realize time's getting short. It
Yes.
seems to me though, even assuming that 17 were there, just imagine that for a second. That would imagine the job consists of two parts. One thing's you really have to take personal responsibility, and everything else you really don't. I mean, that sort of suggests that, if there's lousy legal research, or if, somebody's done lousy job at case management or scheduling, not my problem. And some of those things seem to me to fall out of the category of totally delegable.
Okay,
But
well,
I
I
don't,
think,
I don't know in the next 2 minutes we're gonna resolve this.
yeah, I was just gonna say, I think we put a pin in that and discuss that next time.
Can I just, I was looking for something in this list and I didn't find it, which is sort of sifting the evidence and organizing the record. I mean, that's something that a staff might do, I'm sure at the NLRB where they have large staffs for each member. My father was one of those staff members for years. I'm sure that was one of the things they must have done. I mean, besides drafting decisions and all these other things, they probably had to sift through the evidence and organize the record
Yes.
to help the member.
Can I make one point about the list really quickly?
Yes,
The one that says drafting decisions. I maybe preparing draft decisions in order.
yes,
So that it
Yeah.
doesn't
Yes.
look like they're
Yeah,
actually
yeah.
drafting the
yes,
actual.
absolutely.
Yep. Morgan won.
Excellent. Okay, we can think further about this list the next time. Our next meeting is May 1st at 2:30. Great work today. Really good discussions.
Can I ask since I missed
Yes.
the beginning, what did we do with Jack's original comments about PASs, Arthrex and all that?
Oh, we had a great discussion. You missed it, Jeff.
I know.
Yeah, no, we're gonna acknowledge what I like Jeremy finally called the elephant in the room and put something in the preamble, probably in a footnote, and we're gonna see how that works for next time.
All right, well, I might send some comments about the preamble, if that's appropriate.
Yeah, we did not do a line by line on the preamble. We did very broad discussion.
I'll just send it to Jeremy. He can do whatever he wants with it, or Matthew, whoever.
Okay, great. All right. I think that Andy, do you any closing words?
No, thank you, Nadine. Just thank you to you and to everyone for very thoughtful discussion. I think we improved the product so far in a lot of ways.
Absolutely. Great work. And I will see you all hopefully on May 1st. Thanks
Okay,
so
bye,
much.
everyone.
Have a good evening.
Bye-bye.
All right.